Welcome to Jamaica Citizens Guide. In this video, I'll show you how bail works in Jamaica and how to bail someone. We will look at definition of bail, who can receive bail, who can grant bail, places bail is granted, reasons bail is refused, conditions of bail, and how to bail a person. Definition of bail. Bail can be described as an arrangement in which an accused is released from police custody on certain conditions pending the outcome of a court trial. Who can receive bail? Bail may be granted to a person charged with an offense or who has been convicted for an offense. For the person who is charged with an offense, bail may be granted by a justice of the peace, police officer, or court. Bail application after conviction is made for a person who is appealing his or her conviction and wishes to be out on bail pending the outcome of the appeal. In this case, the bail application is to be made to the same resident magistrate or judge before whom the person was convicted, or to a judge of the Court of Appeal. A convicted person whose bail application is refused by a resident magistrate or judge may appeal against such refusal to the Court of Appeal. Please note that while defendants convicted of crimes can appeal their conviction, only defendants who were granted bail prior to conviction are qualified to apply for bail after conviction during their appeal. In other words, only persons who were given bail before being convicted in court can apply for bail when appealing against their conviction. Who can grant bail? For a person who is charged with an offense, bail may be granted by a justice of the peace, police officer in charge of a police station, or court. When granted bail at a police station by a justice of the peace or police officer, the bail is called a station bail. There are 5 important things to mention about station bail. 1. Station bail cannot be granted to a person charged with murder, treason, or treason felony. Such accused can only be granted bail by a resident magistrate or judge, and the bail application would have to be made in court by the accused person's attorney. 2. Payment required as a condition for station bail cannot be more than 400,000 Jamaican dollars. 3. A justice of the peace or the appropriate police officer can refuse to grant bail. 4. If station bail is refused, it may be granted by the presiding judge when the accused appears in court. And 5. Conditions of station bail may be adjusted or altered by the presiding judge when the accused first appears in court. For example, if the justice of the peace or police officer had required a small sum as condition for bail, the presiding judge might increase the sum amount. In such an event, the defendant would be remanded back into custody until the new condition of bail is satisfied. Please note that the judge is required to give the reason or reasons for making change to the condition or conditions of bail. Places bail is granted. Bail is granted at a police station, any facility declared a bail center, or court. Reasons bail is refused. There are circumstances which can cause bail to be refused to a person charged with an offense. Here are the most popular reasons. Arrested for absconding. Commit an offense while on bail. Wanted on an arrest warrant for a separate offense. Breached a condition of bail. Is considered safer if kept in custody. Is a flight risk. Or there are substantial grounds for believing that the defendant, if released on bail, would commit suicide or interfere with witnesses or otherwise obstruct the course of justice. Conditions of bail. Bail is granted on one or more conditions. Serious offenses typically carry more bail conditions. We will look at bail conditions that must be adhered to before bail can be granted, and we will look at bail conditions which affect the accused after bail is granted. Here is a list of conditions of bail in random order. Surrender passport. This is a bail condition which must be adhered to before the accused can be released from custody. The person acting as surety for the accused must submit the passport of the accused to the court's office within the parish. The purpose of this bail condition is to prevent the accused from legally leaving the island while out on bail. However, the accused may apply to the court for permission to travel and for the release of his or her passport for the purpose of such travel. When applying in writing for permission to travel, the written application must inform the court as to the purpose of the travel, departure and return dates, and other information as the court may require in order to decide whether the permission should be granted. If the accused does not have a passport to surrender, a stop order may be issued instead. 2. Stop order. A stop order on travel puts a ban on the accused person's ability to travel by sea or air from the island. For the order to take effect, the person standing as surety for the accused will be given this completed and signed form from the clerk of court to take to the Passport, Citizenship and Immigration Office. As soon as possible, the surety must take the form to the passport office along with a certified copy of the accused person's birth certificate. After processing instructions from the form, the passport office will issue a sealed confirmation letter to the surety, who must then take it to the court's office. The stop order would then take effect. 3. report to police station. Under this condition of bail, the accused is required to report to a specific police station on a specific day or days of the week between specific hours. This condition of bail is for the accused to prove to the police that he or she has not fled the area he or she currently resides while on bail. On each visit to the police station, the accused person's time and date of visit, along with the signature of the police officer confirming the report, will be entered in a station diary at the police station. It is recommended that the accused person carries his or her own book, an exercise book, in which a police officer must also write the time and date of visit along with the officer's own signature. 4. Not to enter a particular area or not to go to a particular address. This condition of bail prohibits the accused person from going to a specified place so as to prevent conflict between the accused and a person or persons working or residing at that place. 5. Not to make contact with the complainant or any prosecution witness. The purpose of this condition is to prevent the accused from intimidate, pay off, or otherwise pervert the course of justice through means of contacting the complainant or witness. 6. Bail with surety. This condition for bail typically applies to every defendant who is charged with serious offenses. A surety is a person who guarantees the defendant will attend his or her court hearing after being granted bail. The surety is required to deposit a security, cash or other properties, which will be forfeited if the accused person fails to appear in court. A surety can be any adult family member, friend, or sympathizer of the accused. How to bail a person. After all is said, let's look at an example of how to bail someone. Our example is John. John is taken into custody for the offense of wounding with intent. Please note that if John is not charged within 24 hours, John must be released from police custody. If after 24 hours the police refuses to release him, a representative for John should have the matter brought before a justice of the peace or resident magistrate to get John released. However, John has been charged for the offense and is granted bail with one surety. A person wishing to stand as surety for John must first be found suitable by the justice of the peace, police officer, or court, whichever one applies. The following persons cannot provide security for an accused: a person who has a criminal charge pending against him or her in any court, a person charged jointly with the accused or with conspiring, aiding, or abetting the commission of the offense, a police officer. a resident magistrate, judge, or justice of the peace who has considered any issue relating to the bail in respect of the person charged. A person who is entitled to immunity from legal process in Jamaica, and a person who is not resident in Jamaica. The person who has decided to be surety for John must present the following to the court's office within the parish. Form 2, also called Declaration Form. This form is available at the court's office. After obtaining it, the surety must fill out and sign it in the presence of a justice of the peace who will also sign and stamp the form. Instead of a justice of the peace, the surety may have the form signed by a high-ranked police officer or any other person the form approves. 2 passport-size photographs of the surety. The photos must be recent and must be certified by the same person who signs the declaration form. Proof of address. The preferred proof of address is a utility bill which must be recent. Valid photo ID. This may be a Jamaican passport, voter's ID, or driver's license. Security. The surety for John must deposit security that values an amount sufficient to cover the amount set for bail. For the security, the surety may use cash or the relevant documents for movable or immovable properties he or she owns. Again, the value of the property or properties must be sufficient to cover the amount set for bail. The surety must find out if the properties he or she wishes to use as security are acceptable. 2 acceptable properties are land with a registered title and motor vehicles. When the processing of all the relevant documents are completed, and depending on where John is being held, the surety will be given a document to attend the facility where John is being held. The surety will be given instructions from an authorized person at that facility as to when John will be taken to the court's office for completion of the bail process. If no information is given as to when John will be taken to the court's office, the surety should ask about this. The surety is then required to attend the court's office and, in the presence of John and the court officer, will sign the bail bonds. John will then be immediately released from police custody with a copy of the bail bond.